Sharing the responsibilities that come with property ownership may not be easy, but co-owning property gets even more complicated if one owner wants to sell but the other doesn't. In Eli versus Eli, we'll explore whether co-owners can be forced to sell shared property and divide the proceeds, rather than dividing the physical property among the co-owners. Myrtle Eli's family owned 117 acres of farmland in South Dakota for almost 100 years. In 1992, Myrtle deeded a 1/3 undivided interest in 112 acres of the property to each of her 3 sons, Chester, James, and Dale. Dale later transferred his interest to his daughter Jody. The 3 parcels had largely equivalent soil and geographic features. However, because the property was L-shaped, the only way to access the northern parcel from the highway was through the southwesterly parcel. Until 1996, the parcels were rented under one lease and farmed as a single unit. When Chester and James sought to force a sale of the entire deeded property in a South Dakota trial court, Jody asked the court to instead partition the property and give each owner a third of the land. That way, Jody's uncles could sell their land and she could keep her share in the family. Jody wasn't particular about which parcel and even offered to grant an easement over her parcel if needed. However, although her uncle's expert admitted the land could be separated and farmed as parcels, he testified that the property would be worth 10 to 20% more if the parcels were sold together. Finding the reduced value would prejudice Jody's co-owners, the trial court ordered that the property be sold as one unit. Jody appealed to the South Dakota Supreme Court.